Hello, and welcome back to XRP Vault, where we bring you the most recent and intriguing XRP news. We're giving away 10,000 XRP to those who are watching. All you have to do is upvote, subscribe, comment XRP is king and watch the video to the end to be eligible. The winners will be picked next month and publicized on the community page of the channel. Why is the SEC making such a big effort to kill cryptocurrency? Why was the snippet picked for these uses? Can the SEC begin to regulate cryptocurrencies? We'll endeavor to respond to these queries. A pro-XRP legal expert has commented on the sexism lawsuit against Ripple, which appears to be coming to a conclusion. Scott Chamberlain, a former attorney and co-founder of Evernote Extra Pool, listed 5 potential outcomes for the lawsuit in a thread on Twitter on March 10th. These included summary judgments, settlements, and additional litigation. Legal experts claim that the regulator lacks sufficient information to support claims that Ripple CEO Brad Garlinghouse and co-founder Chris Larsen irresponsibly or willfully issued unregistered securities. Chamberlain argued that the selling of XRP by Ripple on foreign exchanges is outside the purview of the court, and that declaring such domestic transactions completed in the US to be subject to summary judgment for Ripple would set a completely new precedent. According to Chamberlain, this lawsuit may look into whether or not Ripple offered unregistered investment contracts when selling XRP tokens in the US. The fifth scenario put forth by the co-founders of Evernote Extra is that the case will be settled if precedents are set regarding the status of XRP as a security and the jurisdiction over international sales. Nonetheless, in accordance with his logic, Judge Analisa Torres denied both parties' requests to exclude a number of expert witnesses, including one each from Chamberlain, Ripples, and Mikis Kurian. According to John Deaton, this was bad for the sexual position. Letitia James, the Attorney General of New York, filed a lawsuit against KuCoin for operating illegally as a securities and commodities broker-dealer in the state. Excellent, bold reporting. Scott Chamberlain, a former attorney and co-founder of Evernote, has made 5 predictions about the SEC's lawsuit against Ripple. According to Chamberlain, the SEC will lose its case against Ripple executives Brad Garlinghouse and Chris Larsen. Attorney John Deaton, the inventor of CryptoLaw, said that the SEC accused officials at Ripple of aiding and abetting the sale of unregistered securities. The SEC must prove that the executives acted carelessly and were unaware that XR was a security. The SEC, according to Chamberlain, lacks evidence. Recognizing these as American transactions, according to the former attorney, would set a precedent. The third prediction is that the court will not accept the claim that XRP is a security. This is based on the extra layer to construct. As a friend of the Chamberlain, Deaton, who represents thousands of XRP holders, asserts that there are no precedents for the sex in this lawsuit. According to the former attorney, the regulator used this action to avoid looking into each XRP trade and addressing overseas sales. According to the former lawyer's most recent prediction, an unregistered investment contract was included in Ripple's US XRP sales. Chamberlain thinks the SEC will reach an agreement as a result of his second and third predictions. According to the former attorney, the protracted legal battle is about to come to an end, at least at the district level, because the SEC believed that waves of XRP sales abroad were understated. Inquiry about its outcome is therefore high. Deaton's predictions and evaluations mostly concur with Chamberlain's, who anticipated no out-of-court settlement until a summary judgment decision that would postpone a trial or appeal. The inventor of the cryptocurrency law also thinks that the marketing of Ripple securities from 2013 to 2017 would be the second and last victory. The cryptocurrency community is eagerly awaiting the decision in the legal dispute between Ripple and the Securities and Exchange Commission, or SEC, which is scheduled to be rendered by the end of March. On March 9th, USC lawyer Jeremy Hogan tweeted that U.S. District Court Judge Analisa Torres might have already decided whether or not XRP is a security. Hogan, a pro-XRP lawyer, reached this conclusion after pointing out that the judge made at least 3 references to the securities law case Marine Bank v. Weaver in her most recent judgment, while discussing the perspective of XRP holders who bought the coin. Hogan offered a case study in which he raised doubt on whether or not the item was usually regarded as a security. The most recent court order mentioned the case of Marine Bank v. Weaver at least 3 times in outlining what a reasonable XR customer would have considered when purchasing the EIGRPI problem. Judge Torres' decision on the DOE bear petitions was 57 pages long. Expert testimony was not objected to by either party in the summary judgment. The lawyer presented his case. Because the court partially granted and partially denied both parties' requests, neither Ripple nor the SEC can claim success. Judge Torres ruled that the principal expert witness for the sexes, Patrick Doody, who was in charge of assessing the purchaser's expectations, could not testify. In contrast, Ripple's experts were permitted to speak about how Ripple's contracts differ from those in the hallway case and how XRP is taxed. The accounting handling of XRP, as well as currency specialists on both XRP and XR, are all allowed to maintain your anonymity, as the Dubar motion's ruling was divided evenly. Stuart Alda, Director of Legal Affairs, according to Rody, the business is confident in its argument and will ultimately succeed. We had confidence in our case from the start, and it has continued to grow with each new ruling. Attorney John Deaton, a supporter of the excerpts, believes that the SEC made a serious error by naming Ripple executives Brad Garlinghouse and Chris Larson in its legal case. According to Deaton, the SEC should have looked into the XRP issuing company Ripple rather than targeting individuals who aren't directly accountable for the alleged securities violations. Initially refrained from asserting that the judge had stated that SEC attorneys had prioritized their own interests over upholding the law. The lawyer said that if the company's own employees disobeyed the law, it was unlikely that the legislation could be enforced. The lawsuit might go one of 5 different ways, according to Scott Chamberlain, a former attorney and co-founder of the permissionless Layer 2 platform Evernode XRP. Chamberlain believes that the issue may ultimately be resolved through settlement, which would set precedents on whether or not XRP is legal and whether or not the court has jurisdiction over purchases made in other countries. A letter in support of Ripple's fair notice defense has already been submitted, citing a recent Supreme Court ruling. The petition was filed in response to a ruling that limited the ability of the U.S. government to punish citizens who failed to disclose foreign financial accounts to the IRS. By highlighting the necessity of federal legislation setting forth clear boundaries for what behaviors are illegal, Ripple highlighted the need for regulatory clarity in the cryptocurrency industry. According to an ex-attorney and Evernote's ex-Ripple co-founder Scott Chamberlain, neither the SEC nor the XRP community seem to have profited from the latest ruling. Following a recent ruling by Judge Analisa Torres, Chamberlain made a statement in which she allowed and denied portions of both sides' applications in an equal ratio. Expert testimony is necessary for Ripple and the SEC to support their claims and evidence regarding XRP. Neither the SEC nor the expert community appear to have profited from this ruling since the court partially approved and partially rejected both sides' motions. The SEC had appointed this company as the primary expert witness to investigate investor expectations for XRP. Due in part to Deaton's disclosure of the name of the attractive expert witness, SEC lawyers attempted to have Judge Torres bar John Dean and the XRP community attorney from taking part in the action. This was an unexpected consequence of the Dodd-Bear concerns. The judge did not forbid Deaton from testifying in court on behalf of XRP holders but rather instructed him to refrain from being greedy while doing that job. Similar opinions were voiced by an additional community attorney named Jeremy Hogan. He claimed that the SEC must demonstrate that investors had a reasonable expectation of profit from Ripple's efforts, and that duty was essential in proving this, while the judge ruled in favor of the Sexon expert witness number 3, which Ripple had deemed irrelevant and unreasonably prejudicial. Hogan thinks that the topic of a fair expectation of profits can be addressed by expert opinion regarding Ripple's incentives and measures to impact the extra price. But he thinks it's weak sauce, which means it won't work in this situation. John Deaton, an attorney, has said in its enforcement lawsuit against Ripple Labs, the U.S. Securities and Exchange Commission made a critical blunder in correctly identifying Ripple executives Chris Larson and Brad Garlinghouse. In a lengthy Twitter discussion yesterday, the inventor of CryptoLaw attempted to explain why Judge Analisa Torres dismissed sexism concerns to Ripple expert testimony on the non-security status of XRP by other authorities. He claimed that the question of whether Ripple authorities acted foolishly by failing to realize that X was a security was answered by this testimony. For the court to find the executives guilty of encouraging the sale of unregistered securities, the SEC will need to demonstrate this, as the attorney previously indicated. The lawyer repeatedly asserted that the SEC and other government organizations had deemed Extract to be a non-security and that, by doing so, the agency had placed an unnecessary burden on itself. According to Deaton, the regulator may have taken this measure to coerce a settlement or to reduce the strength of the ripple effect in the nascent market. Nonetheless, he believed that this was a serious error and that the regulator will probably certainly lose this poll. The lawyer for the 75,000 XRP holders who are parties to the dispute has predicted that the court's verdict in the legal dispute will come quickly.